The Supreme Court hands down judgment this morning in the case of G against G. This is a brief summary of the court's reasoning. The appeal raises important questions of law as to the interplay between the 1980 Hague Convention, which enables the prompt return of a wrongfully abducted child to her country of habitual residence, and the 1951 Geneva Convention, which protects those entitled to asylum from being returned to the country from which they sought refuge. There are not only two conventions, but also two separate sets of proceedings with appeals to different courts. The proceedings under the 1980 Hague Convention are determined by the High Court, with the potential for appeals to the Court of Appeal and to this court, whilst the asylum application is determined by the Home Secretary, with the potential for appeals to the First-Tier Tribunal, the Upper Tribunal, the Court of Appeal, and to this court. The existence of these two separate sets of proceedings also raises important legal and practical points as to the interplay between them. The parties are the parents of an 8-year-old girl, whom I shall call G. G was born in South Africa, where she has been habitually resident all her life. In March 2020, G's mother, the appellant, wrongfully removed G from South Africa to England in breach of G's father's rights of custody. G's father, the respondent, applied for an order under the 1980 Hague Convention for G's return to South Africa. G's mother opposes his application under the 1980 Hague Convention on the ground that return would expose G to a grave risk of harm. However, in addition to relying on the 1980 Hague Convention, G's mother opposes the return of G, asserting that if G is entitled to asylum, she is protected from being returned to South Africa under the principles contained in the 1951 Geneva Convention. The mother asserts that this protection under the 1951 Geneva Convention prevents a return order being made or alternatively being implemented under the 1980 Hague Convention until the asylum application has been determined. The facts in relation to the mother's asylum claim is that she identifies as lesbian. She alleges that after separating from the respondent and coming out, her family subjected her to death threats and violence. On arrival in England, she applied for asylum on the basis of her fear of persecution by her family. She listed G as a dependent on her asylum application. G has not made an asylum application in her own right. A core principle of asylum law is that refugees are protected from being returned to the country in which they have a well-founded fear of persecution. The High Court judge, dealing with the 1980 Hague Convention proceedings, who had been misinformed that G had made her own asylum application, stayed the 1980 Hague Convention proceedings pending determination by the Home Secretary of the asylum claim. The Court of Appeal, having been informed that there was no separate application by G for asylum, but rather that G had been named as a dependent on her mother's application, lifted the stay on the basis that where G was named as a dependent, a return order in respect of G could be both made and implemented in the 1980 Hague Convention proceedings, prior to the determination by the Home Secretary of the mother's asylum application. The Court of Appeal also held that if G had made her own separate application for asylum, then, whilst a return order could be made, it could not be implemented during the pendency of the application. The Court of Appeal also gave detailed guidance as to the discretion to stay the 1980 Hague Convention proceedings, where a child and/or the taking parent had applied for or been granted refugee status. The Court of Appeal stated that as a general proposition, the High Court should be slow to stay a 1980 Hague Convention application prior to any determination of a pending asylum application. G's mother appeals to the Supreme Court on 3 grounds. First, she contends that her asylum application could also be understood to be an asylum application by G, so that a return order should not be implemented until the asylum application had been determined. Second, that the High Court should not make a return order where there is a pending asylum claim. And third, the guidance as to the High Court being slow to stay a 1980 Hague Convention application was incorrect. The Supreme Court unanimously allows the appeal on ground 1 and unanimously dismisses the appeal on grounds 2 and 3 for the reasons set out in a judgment given by myself, with which the other justices agree. The reasons for allowing the appeal on the first ground can be summarized as follows. An asylum application which lists a child as a dependent is also an asylum claim by that child if objectively it can be understood as such. That will normally be the case. The adult's ground for fearing persecution are likely to apply to their child, and an omission by the child to make an application in their own right cannot be determinative. This means that a return order under the 1980 Hague Convention cannot be implemented until the asylum application has been determined, if that application objectively can be understood to be an application on behalf of G. Furthermore, an asylum claim is not determined until the conclusion of any appeal, so that a return order cannot be implemented in 1980 Hague Convention proceedings in respect of a child with a pending in-country appeal. In other words, a pending in-country appeal bars the implementation of a return order. Because of the time taken by the in-country appeal process, this is likely to have a devastating impact on 1980 Hague Convention proceedings. So, urgent consideration should be given to a legislative solution. In relation to grounds 2 and 3, these 2 conventions must operate hand in hand in accordance with the obligations of expedition and priority imposed for the benefit of children under the 1980 Hague Convention. This means that as a general proposition, the High Court should be slow to stay 1980 Hague Convention proceedings, and there is no reason why a return order cannot be made as opposed to being implemented. The mother's appeal must therefore be allowed in part. The case is remitted to the High Court for determination of the 1980 Hague Convention proceedings in the light of this judgment. The court is now adjourned.